Okay, there's still a few people joining, but I think we'll make a start. Um, my name is James Maurici KC. Thank you for joining us, and welcome to Landmark Chambers Access to Environmental Information Update webinar. Delighted to see so many of you joining us today, and still joining according to the participants' figures that keep going up. I hope you find today's presentations and discussion useful. I'm chairing today and speaking at the end, and I'm joined by my colleagues Jacqueline Lean, Nicholas Grant, and Alex Shattoc, whom I will properly introduce to you in a moment. But I'll now move to introduce you to the speakers today. So I'm joined, as I've said, by Jacqueline, Nicholas, and Alex, all, of course, barristers at Landmark Chambers, all practicing in environmental law amongst other things, and all of whom have been involved in a number of the leading cases over recent months, including Finch, Fry, and the ongoing Whitehaven mine case. All three are my co-editors and co-authors on the Landmark Chambers Aarhus blog, about which more in a moment. And all of them have experience either before the Aarhus Compliance Committee or in a number of cases in our domestic courts involving Aarhus issues. And they are all, of course, highly rated and regarded by the directories, and I'm delighted that they are speaking at this webinar today. So I'm just going to do a plug for two things. One is the Aarhus blog. It comes out every 2 weeks. You can sign up on our website to be emailed the blog. We cover a wide range of topics. Anything Aarhus related is within our scope. That does include environmental information, but obviously goes well beyond that. So if you have not seen it or looked at it or signed up to it, please do. And secondly, the other thing that I must refer to is that Jacqueline and myself were co-authors of part 3 of the 6th edition of Information Rights, which was published late last year. And part 3 is the part that deals with, of course, access to environmental information. As you've seen, in terms of what's being covered today, Jacqueline's covering latest cases on EIR disclosure exemptions. Nick is dealing with disclosure of viability assessments, and Alex is dealing with getting hold of documents for planning and environmental public law litigation. I'm going to cover the role of the Aarhus Convention in EIR case law. So without more, let's get on with the first of the talks, and I shall see you all towards the end for my session.
Good morning, everyone. As James indicated, I'm going to be talking about disclosure of viability assessments, something that's becoming more and more contested as you can imagine local communities get involved, and indeed hospitals get involved and try and ensure that they're receiving as much money as possible via Section 106 and SIL type contributions. I'll be taking it in 2 parts. One is the general law, and one, forgive me, I've run ahead, and then I'm going to talk about and compare it with the position under the EIRs, both of which are tools available to try and get hold of these documents. So under the general law, particularly when something's going to committee, Section 100D of the Local Government Act 1972 provides that background papers for meetings of the principal councils have to be both listed and then open to inspection by the public. Now, background papers are those which the proper officer, whose job it is to comply with this section, are those which he or she considers disclosed facts on which the committee report is based, and have been relied on to a material extent in preparing that report. Now, obviously, the viability assessments would usually come under that, given if there is to be a reduction on, say, affordable housing, it's usually viability that's used as the reason for that. Now, nothing in Section 100D requires the disclosure of a document which contains, exempt information, and that is defined in Part L, Section 100L. An info is exempt insofar as it's relating to the financial business affairs of any particular person, if and so long as, in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing it. A short point on this, which is actually not related to viability assessments, but one which it's helpful to bear in mind if you are going to try and use this tool to obtain a viability assessment, is the fact that the right to know provision, section 100D, usually require disclosure of information in good time for members of the public to be able to digest it and make intelligent representations. That's what we get from the Maurici case. That's recently been reaffirmed in Holborn Studios 2, which I'll come to in a moment. So what's timely turns on factors such as character, audience, and bearing on the decision. And in viability assessments, they're usually pretty complicated, unless you're a surveyor who spends all their time embedded with this. I certainly think that they probably need to be disclosed, if they're being disclosed, more than, say, 36 hours before the committee meeting. Prior to 2019, in the old NPPF world, viability assessments weren't usually required to be disclosed under section 100D. That all came from the High Court in Perry. That was a case where there had been 2 applications for mixed-use development. A viability assessment had been submitted confidentially. It had never been made public, and a claim was brought saying, at the very least, the committee, but actually, we as a whole, the public, should have been able to see this. The High Court said, no, there's no common law right for the committee to see the report, and as the information is exempt information, it didn't need to be disclosed. The purpose of the exempt information statutory provision is to allow negotiation and discussion, so it would fundamentally undermine that if viability assessments were required to be disclosed. Fast forward to 2019, and we get updates to the NPPF and the PPG. And the NPPF puts the onus on developers to explain why they can't make, for example, affordable housing contributions, and states very clearly that viability appraisals should both reflect the PPG, include standardized inputs, and be made publicly available. So this is an attempt to row back on the idea that these are highly confidential documents, which include highly confidential, unique business analysis of the situation, and it says use the standard inputs, and by the way, these are probably going to be public. PPG updates at the same time include requirements on how viability exercises should be undertaken. So that brings us to Holborn Studios 2. This is a case where the leaseholder of a particular site was challenging the interested parties' plans to develop. 2 viability reports had been prepared, one with numbers that had already been blanked out, and the other one that was only summarized in the public domain. And as I'll come to in a moment, there were questions about those summaries. What was in the public domain was the claimant alleged, frankly, incomprehensible. A JR was brought on the basis of non-compliance with the Local Government Act, and as said, material in the public domain being incomprehensible. And in this case, in a departure from Perry, which is what Hackney, the local authority, had relied on, that judicial review was allowed. It was Mr. Justice Dove took it into 2 stages. First, he said, look, there's significant quantities of information in this which are obviously important for the committee report section on viability. So really, this is about whether it was exempt information. The defendant had argued they'd substantially complied in circumstances where they'd put some information, some summaries in the public domain, and the remaining material was exempt. And those arguments were frankly rejected. Mr. Justice Dove explained that if you're going to maintain something as exempt material, you need to show the public interest in maintaining that exemption outweighs the public interest in disclosing. And since the changes in the NPPF and PPG, there is now an expectation that that viability assessments will be in the public domain. So he deliberately departed from Perry based on that policy change. He also is particularly critical of the information in the public domain, what had been put there, describing it as opaque, unexplained, irreconcilable, and frankly, entirely prevented objectors engaging in viability discussions. But what happens if you're in the post-2019 world, but you're dealing with a decision that was made pre-NPPF 2019? Well, that's what came up in the Worcestershire Acute Hospitals Trust case. This was a challenge to the grant of planning permission for South Worcester Urban Extension. It's a major project, several thousand homes, hectares of commercial space. The local NHS trust had sought Section 106 contributions of millions of pounds. It started off at 3.3, and over the course of the development, over the course of the consideration, was reduced to 1.8. But viability had already been used to reduce affordable housing and in relation to highways contributions. And the officer's report advised that the viability showed that basically any NHS contributions would come at the expense of highways or yet further affordable housing. The decisions were taken in 2018, as I said, pre-NPPF change, sorry, and it was argued that there was a breach of section 100D. It was accepted before the High Court that materials were background papers unless they included exempt information, and there was no real dispute that it contained confidential information. So the issue was the paragraph 10 balance. And in this case, Mr. Justice Holgate said, as the decisions were taken pre-NPPF, the NPPF 2019, there wasn't that expectation that things would be put in the public domain. They did include more confidential information, and so he decided to follow Perry. He did not follow the more recent decision in Holborn Studios too. He also included a number of interesting points on those on the operation of section 100D. So that balancing exercise, for example, he says that's a matter for a judgment for officers, subject only to review on the rationality basis. And that'll be interesting when we get on to EIRs, because it's the tribunal that seems to take the view that in the EIR circumstance, it's for it to decide where the balance lies. He makes clear that section 100D does not provide for the redaction of confidential information or part disclosure, but there is an obligation to keep under review the question of whether the material now needs to be disclosed. That's not every Monday you have to relook at it, but if circumstances materially change, then the proper officer has to relook at the balance that's been struck. He also deals with the consequences of breach. So if you do get home on there being a breach of section 100D, and he makes clear that the decision is not automatically unlawful, whether it'll get quashed, sorry, not automatically quashed, that should say, not automatically unlawful. Whether it's quashed depends on whether there's been substantial compliance. So for example, what's been put in the public domain, and whether there's been material prejudice to the public. So in summary, it's highly likely that if a viability assessment is being used to avoid or reduce section 106 obligations, those assessments will be considered background documents. They can't be part disclosed, and if you're in a decision made pre-2019, they likely contain exempt information, and the balance to be struck whilst being a matter for officers is likely to come down in favour of maintaining the exemption. If you're in a post-2019 world, then it should contain standardised inputs, and it's highly likely the public interest will favour disclosure. Again, if there's a breach, it doesn't automatically mean you quash the decision, but for members of the public wanting to engage in this, it's really important effectively to engage early. One of the issues in the Malvern case was one of the points raised with the hospital trust, who'd come along and asked for its millions of pounds, hadn't actually engaged early. So engage early, ask for the viability assessment before the decision is made, so that you really can show that you need it and it's material to the representations you want to make. So that's general law. I'll move on now to the second part, which is the environmental information regulations. So these implement an EU directive, which in turn implements the Aarhus Convention's information pillars. In broad outline, a public authority has to proactively make environmental information that it holds available, unless that information is covered by Regulation 12, and make environmental information available on request. That's Regulation 5. Now, there are exemptions from or exceptions from the on request provisions, and those are outlined in Regulation 12. So the public authority may refuse to disclose if one of the exceptions applies. I'll come back to what those are in a moment. And two, the public interest in maintaining that exception outweighs the duty to disclose. And just to be clear, that means the public interest in all the exceptions put together must outweigh the public interest in disclosure. And there is a presumption in favour of disclosure. So what are the exceptions? In relation to viability, there are three that you'll see time and time again. There are two you see time and time again, and one additional one. The first is Regulation 12.5c, which is an exception to the extent disclosure would adversely affect IP rights. The second is an exception to the extent disclosure would adversely affect the confidentiality of commercial or industrial information. The third is the extent to which disclosure would adversely affect the interests of a person who was not under a legal obligation to supply the information, didn't supply it in circumstances that any other person would be entitled to disclose it, and that person, the supplier, does not consent. So what's environmental information? And do viability assessments fall within it? Well, we have a pretty lengthy definition. In fact, it covers 2 slides. This is copied across direct from the Aarhus Convention, or copied across from the directive, which copies it across from the Aarhus Convention. So we see it. I won't read it all out. Subsection A talks about the state of elements of the environment. Subsection C talks about measures, including administrative measures like policies, legislation, plans, or programs likely to affect the state of those elements. Subsection E gets into cost benefit and economic analysis and assumptions, and F is the state of human health. Now, the Information Commissioner's Office interprets this really broadly and says online that basically, if it's information that informs the public about matters affecting the environment or enables them to participate in decision making, it will usually be environmental information. And that's reflected in the Shattoc case, the Lend-Lease case from 2014, I think the decision is. But in effect, this was a request for the viability assessment in connection with a planning application by Lend-Lease to redevelop a large area of Elephant and Castle. The viability assessment was submitted to the LPA on a private and confidential basis. Again, be clear, this is pre-2019 NPPF. And the tribunal indicated it was environmental information. Now, it based this largely or partly on size. It said the regeneration program was enormous, and so it's likely to affect the state of the landscape as an element of the environment. So we're in Reg 2.1c territory, and the viability assessment was an economic analysis within the framework of that measure, so 2.1e. I should say, though, that in other decisions, more recent decisions I've seen for not nearly as enormous regeneration, there doesn't seem to be any issue taken that viability assessments are environmental information. And indeed, that's what we see on some of these later decisions. So then it becomes a question of what exceptions are engaged. So as I said at the start, normally you get into 12.5e and F, which is commercial negotiations, and it's confidential to me. And you see that in the Lend-Lease case, but sometimes you get into IP rights territory. And again, an example of this is the Lend-Lease case, where one of the appendices to the viability assessment was a specific financial model developed by Lend-Lease as a tool to assess large projects. It's called, it was Appendix 22. And again, so because of that specific bit, Regulation 12.5c was engaged. So assuming you've got an exception, how do you balance the public interest? Now, this is always a fact-specific case, very fact-specific, but you do see certain common themes and examples coming through. So, for example, in disclosing, there's an interest in transparency, accountability, particularly if there's an unclear bargain. In one of the more recent cases, there was a concern that wasn't a viability assessment, but it was similar, and there was a concern that a council had bought a land for way above market value. Public participation, obviously, and the local importance of issues. Again, this is something that was brought out in one of the more recent cases. Against that, you have harm to economic interests. The real concerns arise if it would undercut the viability of schemes or social elements. So, for example, if a developer says, look, if you put this in the public domain, our commercial tenants are going to understand what we've predicted, and so they're going to use that to effectively undercut what price we can get, and that in turn is going to undercut our social elements, our affordable housing. That's a real incentive against disclosure. If it contains trade secrets or similar, again, important, or an argument in favor of disclosure, maintaining commercial confidences, etc. It's difficult to generalize on how these come out, precisely because it's so fact specific in every case. But what is interesting, and where we depart from the more general law, is that test and the results can impact differently on different parts of the viability assessment. Again, I'm using Lend-Lease as an example. So Appendix 22, that commercial proprietary model, was a commercial secret. The harm outweighed the disclosure. The landlord's projections of commercial sales and rentals, again, was of great sensitivity, because the tribunal took the view that commercial tenants would try and undercut, or would say, well, you only predicted you'd make a rent of X from me, so that's all I'm going to pay. And that would damage both the delivery of the project and its social content, things like affordable housing. Again, not disclosed. But that same reasoning didn't apply to private purchasers who are more influenced by the market. Is this a 320 grand flat? Look at all the other flats, yes or no. And indeed, social housing providers. The rest of the viability assessment, it concluded, was less sensitive. So what you do see, and what the tribunal ordered in this case, is it leads to disclosure of parts. unlike you get under the general law. That's it from me. I hope it's been helpful, and I will now hand over to Alex.
Thanks, Nick. Good morning, everyone. Information. We all need it. Without it, we'd be in the... And not just metaphorically. Light itself can be considered information. Information is a concept covering anything that has the power to inform, to be interpreted, to be understood. Any natural process that's not truly random can be said to convey information. Unfortunately, I only have a few minutes today to impart some information of my own, and so I will necessarily narrow the scope of this talk to the subject of environmental information, and in particular, how to get your hands on it, environmental information, in order to bring a public law challenge. What's on the menu? Well, for brunch today, we have environmental information 3 ways: hard-boiled, poached, and deviled. EIR, that's hard-boiled because it takes a while, and sometimes it's a letdown, but conveniently, you can save it in the fridge for later. Duty of candor, that's poached, much like poached eggs. It should be straightforward, the duty of candor, but it rarely is, and you do need to eat it straight away. More on that later. And then finally, specific disclosure in JR, that's deviled, a bit of an adventurous one, this, but it can be delicious under the right conditions. So you've defined information as an abstract concept. You've realized it's environmental information you want, and you've decided it's for the purposes of judicial review. Next question, how to get it? Well, first of all, you could make a request under the environmental information regs. This can be quite a good route. You can get a lot of useful and interesting information this way, particularly good for internal or unpublished guidance document. I always ask if such documents exist, even if I'm not aware of them, because they might do, worth asking. You can ask for a breakdown too, how many exits happened last year, etc., etc. And if they don't hold the information, that's useful too, because it usually means they're not monitoring, which of itself can be cause for concern in the environmental sphere. There's no relevance test, which is nice. You just ask for what you want and you should get it. Motivation too is also irrelevant. Once a week, I send out a detailed EIR request to a different public body, and I don't even read the responses. I just do it for fun, and that's okay. It's for them to justify refusal. And particularly when litigation is ongoing, you may get some surprising details, this bit at the end, from the public body's helpful information team, who might not be speaking to the perhaps ever so slightly less helpful sometimes litigation team. So always worth an EIR request, even if you've got an ongoing JR. I've had some fun with the Home Office revealing things via FOI that probably annoyed their litigation team in retrospect. So as I said, it's worth firing off an EIR sometimes, even if you're asking for information under the duty of candor. Next slide, just some tips on this slide for a good EIR FOI request. You'll get the slides after the presentation. A lot of it's reasonably straightforward, fairly basic. Might be teaching grandma eggs. Notice that a little egg-based sub-theme is emerging in this talk. The information that we receive often takes some surprising twists and turns, but always important to remind yourself of the basics. Be specific. That's a big one. Don't ramble on about egg. Get to the point. But at the same time, try and capture every possible bit of information you can. Don't let them wriggle out by being so specific you forget to ask if they had an obvious alternative to the thing you think they have. Guidance, memos, briefing notes, etc. Because they may well say, well, you never asked us if we had a briefing note, you only asked us for a guidance note, etc. So just try and capture everything you can. Don't ask for everything from the last 50 years because they can refuse tasks that take too much time. You might want to split the request with your mates too if you're worried that you're asking for too much. If you both ask for a little bit each, then that might go down better. And don't ask for information too often, or they may characterize you as vexatious and label the request manifestly unreasonable under Reg 12, which they can do. And essentially, in those circumstances, they put you on the naughty list. And once you're on the naughty list, it doesn't matter how nicely you ask Santa for some environmental information,
Christmas, you might not get it. Might get a lump of coal, which may or may not be relevant depending on your prospective environmental challenge, but you won't get the information. So try to avoid that situation. Some of my clients have been characterized as vexatious, and it is a pain for them to get more information from that point onwards. What information can we glean from this next slide? Well, a note of caution here. EIA requests take a while, right? And you're on a time limit for judicial review. So just bear that in mind, EIR, I should say. 6 weeks for a planning decision, judicial review time limits, and in any event, promptly. And so bear in mind, your public body here can extend. So the EIR is a good tool prior to a decision, good tool during litigation, but right after the decision and you need the information now, might not be the best idea to wait for it to come before you bring your challenge, because your challenge may then be out of time. We do, however, have something else, the second in our egg-based triptych, duty of candor. Public bodies cannot win litigation at all costs. They can't seek to do that. They need to help you and the court understand how a decision was reached under the duty of candor. And that usually means producing the relevant information. Quite a lot of case law on the DOC, DBH, OMG, but usefully summarized by Mr. Justice Fordham in the recent police superintendent's case. And in summary, basically, just be helpful. If you're on the defendant side, produce what is needed to understand the decision. And Mr. Justice Fordham didn't mention that being helpful also includes not sending over pleadings as locked PDFs that you can't copy and paste from, but that was probably an oversight. That's important too. But he did say you can't be selective. You can redact as well if that's justified, but ideally you should produce the original docs, and the duty of candor applies at the permission stage and indeed the pre-action stage too. Little footnote here, we have a recent decision of Sir Duncan Ouseley in the Cumbria coal mine case that James, Nick and me are involved in on different sides. A characteristically chunky judgment from Sir Duncan, but one which perhaps doesn't sit well with what Fordham says about the duty of candor. This was about whether a ministerial submission needed to be disclosed. Nick, I can't quite remember what happened in that case, but we'll have to see. My client, Friends of the Earth, says that Sir Duncan and Mr. Justice Fordham can't both be right. So we have applied. The Court of Appeal might give you a hint as to how that went from my side, but we will see if the Court of Appeal decide to pick this one up out of that selection box of potential appeal points. So might not be the final story here. Next slide, we've got some duty of candor tips. What are those tips? Ask early and often. Remind your public body of the case law. Be clear, it's not an EIR request. They shouldn't treat it as one, but sometimes they do. Don't ask for 10 different things in your pre-action letter. Be selective. Renew your request if they've refused after you get permission. You have other tools too to get that information. Don't forget about your Part 18 requests as well, CPR. And worst comes to worst, number 3 in our list today, you can make an application for specific disclosure. Why is there a picture of Tweed on that slide? Well, it's because it's the leading case, Tweed and the Parades Commission. Tweed says you can apply for disclosure in JR and you get it if disclosure is necessary to resolve the matter fairly and justly. Fairly rare, these applications. I've only done it twice. The thing is, you need to show why what you're seeking is necessary to resolve the matter fairly and justly. So you need to link it to the pleaded case or either your arguments or their grounds. In a case against the Home Office, I was able to get the contractual performance data of failed asylum seeker accommodation providers in a disclosure application, but that was because it was a systemic challenge and the case was defended on the basis that there was no systemic problem. So the contractual performance of the providers was very relevant to our case, and indeed when it was disclosed, clearly demonstrated there was a systemic problem, as the court later found. Again, I can't remember what the outcome of our specific disclosure application was in the Cumbria coal mine case, but perhaps Nick can remind us later in questions. Final point just to be aware of as well. If there are live legal proceedings, including judicial review, that's potentially another excuse not to disclose under regulations. We're talking here about the adversely affect course of justice exception. It's a bit dubious, in my view, where reliance is placed on a live JR and the information is otherwise disclosable under the regs. Query how it has any impact on justice if the information comes into the public domain, particularly as the facts in JR are not meant to be contested. But that's probably one for the ICO if refusals keep happening on this basis. So, in conclusion, I have imparted some information over the course of this presentation on 3 different ways you can get the documents you want in a JR or statutory review. It's fair to say they all have their strengths and weaknesses, and no reason why you can't pursue multiple avenues to get what you need. You might even say there's no need to put all your eggs in one basket.
Good morning, everyone. Following on from the richness of Alex's presentation, I'm afraid we now turn to something that's a little bit more akin to a slice of dry toast, which is the disclosure exemptions and a few of the latest, that should be in inverted commas for reasons that will become apparent shortly, cases on those issues. So by way of a quick overview recap, there's broadly 3 categories of exemptions to the duty to disclose under the EIR. The first category is refusal on procedural grounds. So that's things like the request is vague, the request is manifestly unreasonable, or the public authority doesn't hold the information requested. The second category are these class-based exemptions. So in particular, the class-based exemption that the information includes personal data and the applicant isn't the data subject. There's the one of the request relates to incomplete material, or the request involves disclosure in internal communications. And then the third category is that disclosure of the information would adversely affect any of the matters specified in Regulation 12.5. And just by way of a quick recap, that includes, for example, at point A, international relations, defence, national security, public safety. B, the course of justice, the ability of a person to receive a fair trial, or the ability of a public authority to conduct an inquiry of a criminal or disciplinary nature. D and E, a couple to do with confidentiality. And G, the protection of the environment to which the information relates. Now, except for the personal data exemption, which had its own quite specific regime in Reg 13, all of the exemptions are subject to the public interest test, essentially, which you find in Reg 12.1. That is, that in all the circumstances of the case, whether or not the public interest in maintaining the exception outweighs the public interest in disclosing the information. Now, a lot of the cases that I'm going to touch on, and indeed a lot of the cases that have been floating around on this, often go into some detail on that public interest test. I'm only going to touch on that quite lightly, because what I'm focusing on mainly in the talk today are the consideration of the exceptions themselves. Now, first category, refusal on procedural grounds. The 3 cases I want to just pick up on in terms of what's meant by manifestly unreasonable, and perhaps this may be of interest to Alex, particularly in light of what I'm going to raise with the Vesco case. Now, there's quite a lot of overlap between the manifestly unreasonable test in the EIR and the language of the vexatious request under the FOIA, but that only goes so far. As we'll see from the first case, which is the Vesco case from 2019. Now, this is kind of why I say that perhaps we should treat latest in the heading of this talk as being in the slight inverted comma, but it's quite an important case from the upper tribunal that has fed through into the later consideration of this. So I thought it would just help to do a quick recap on Vesco, even though it's a little, perhaps a teenager in terms of latest cases. So in this case, Ms. Vesco made a request to the GLD for information relating to the gas safety installation and use regulations 1998. Essentially, she was very concerned about flue emissions in neighbouring properties. And there had been previous requests made to different bodies to try and get information about flue emissions over the history of this matter. And that factor, the fact that there had been a number of different requests and to different bodies, factored into the council's, the GLD's decision, and certainly the ICO's decision, upholding the refusal to disclose on the grounds that was manifestly unreasonable. Now, the ICO's decision, which used the language of a request being vexatious, was upheld almost in similar terms, or almost in the same terms, by the first tier tribunal, but the decision was overturned by the upper tribunal. And why this case is particularly interesting is because of the advice and the general guidance that the upper tribunal gives on how a decision maker, and importantly how the FTT on an appeal should go about looking at this manifestly unreasonable exemption. So essentially they stressed that there's a 3-stage test that's got to be applied when deciding whether information can be withheld under that exemption. The first question is the request manifestly unreasonable? So it's not enough, you don't stop there, that's the starting point. The second point is, if so, does the public interest in maintaining the exception outweigh the public interest in disclosing the information in all the circumstances of the case? And thirdly, and importantly, does the presumption in favour of disclosure mean that the information should be disclosed? And as I said, the upper tribunal acknowledged that there was quite a lot of overlap between what was meant by manifestly unreasonable under the EIR and vexatious under the FOIA regime, but that only went to question 1. And also, and I sort of float this in terms of the case I'm going to come on to in a moment, the upper tribunal also acknowledged that when you were looking at whether a request was manifestly unreasonable, that matters such as previous requests and the cost of compliance with the request could be relevant matters for a decision maker under question 1. Could be something they could look at, and indeed outlined a few factors by reference to the Dransfield case from 2012 that a decision maker or a tribunal might want to look at on that, highlighting that the one thing could be relevant would be the burden on the public authority, since one aim of the provision was to protect resources of the public authority from being squandered. Second, and this is where I just do a mental flag to Alex, the motive of the applicant. They did go on to say, although no reason has to be given, it's found that motive can be relevant. For example, a malicious motive may point to vexatiousness, but the absence of the malicious motive does not point to a request not being vexatious. I don't think anybody's thought about just doing it because you can, but who knows, watch this space. Thirdly, relevant fact would be the value or serious purpose of the request. And fourthly, and this is something that comes up in the later cases, the harassment or distress of staff. Now, tribunal also stressed that wasn't an exhaustive checklist, and that there were a number of factors that could be relevant, including in the context of previous requests, things like how many, subject matter, breadth, pattern, things like that. But there are a whole host of factors that can be looked at under the question. But the second stage then has to be looked at in terms of the public interest in maintaining the exception and whether that outweighed the public interest in disclosing the information and circumstances of the case, and also the third test of the presumption of disclosure. And where it felt the FTT had particularly gone wrong in this case was, firstly, it wasn't entirely clear how the FTT had gone about its decision making. And there was a concern in particular that some of the language that was used was the request being vexatious, seemed to have just been translated across from the ICO's decision into the FTT's decision. And essentially, the tribunal said, well, there may well be cases in which it's clear from the decision that you've reached the same conclusion as the ICO, but you need to make that clear. It needs to be clear it's your decision. It can't just look like you're rubber stamping the ICO's decision. So that was stressing the point that the FTT is required to read its own view on the relevant tests and to be independent and impartial as between the parties. It's not just there on some sort of JR function or to rubber stamp the ICO's decision. It also wasn't clear to the upper tribunal that the requirements, the 3-stage requirements of the test had been properly applied. And with regards to the first limb, the manifestly unreasonable test, it wasn't clear that that had been properly applied, and there was no recognition, or at least inadequate recognition, of the fact that the manifestly unreasonable test was a high one. And so the upper tribunal held that the first tier tribunal had erred in law and or had provided inadequate reasons. And just picking up on harassment and distress, one thing that was picked up in that decision, there was no consideration of that or evidence that there had been any problem as a result of these requests being made. So moving on then to two other cases on manifestly unreasonable, which postdated the Vesco case. And this is really on the issue of burden and cost of compliance. Now, obviously Invesco recognised that could be a relevant factor in Kane and the Information Commissioner, a case from 2020. Mr. Kane had requested information from Tamworth Council relating to open space contributions and money spent on enhancing open space facilities. And broadly, the background to that was I'm a would-be developer, I'm a proposed developer, and I kind of want to know how this is working out to inform my own decision-making process about things, what to offer a 106, what's likely to be required, and such like. The council refused the request on the grounds it was manifestly unreasonable. The information wasn't held in the form requested, and providing it would take more than 18 hours and require a manifest, big trawl through lots of other documents. Now, the 18 hours point, under the EIR, unlike under the FOIA, there's no figure or hours figure that's given indicatively for what may or may not be a reasonable amount of time, or there's a reasonable burden for a public authority to spend when dealing with a request. But the tribunal in that case and the ICO before it were happy to essentially, it seems, look at the 18 hours figure as a rough and ready, okay, it's more than that here. We think in all circumstances of the case, we agree it's manifestly unreasonable. But also it's very clear they went beyond that. You can see that they point out the request covered 10 years. They were confident the work would be very substantial, and it could well take several weeks of full-time work for one officer to pull it together. And looking at the other things that they were responsible for, the officers would be having to deal with it, they agreed that this was manifestly unreasonable. And they also considered the public interest in disclosure didn't outweigh the public interest in maintaining the exception in that case, or to be more accurate, putting it the other way around. And they set out a number of factors why that was in this case. But also one thing they did point to was the fact there was some information available on the council's website, which went some way towards answering the request about open space facilities and such like. And also that whilst they recognised the legitimate interest that Mr. Kane had in understanding the council's approach to open space, because that might inform his thinking on his own applications, that it was open to him to put forward whether he thought was appropriate in the Section 106 agreement. He wasn't necessarily bound by what had happened in previous cases. That was followed by Watson, an Information Commissioner, and this 2022, again, we're still in the first tier tribunal here. And this was raw data. What was thought was raw data, which sat behind a noise and vibration report about a proposed new bypass. And again, the exemption relied on was that it would be manifestly unreasonable because the cost of compliance would be too great for the authority's resources. But what's important to stress here is that 18 hours may have been picked up in Kane, but the FTT was clear in this Watson case that 18 hours isn't determinative. So you don't import it as a yardstick into the EIR from the other regime, and it was entitled to take other factors into account. And looking at all the circumstances in that case, the tribunal felt actually the request wasn't manifestly unreasonable, and rather than remitting it back to the ICO, it actually substituted its own decision notice requiring disclosure of the information. Moving on to class-based exemptions, first one to pick up on is data protection. Again, FTT decision, but kind of helpful because of some of the principles it draws out from previous authorities. So Mr. Miller was quite concerned about some TPOs on some land that he owned, which had been put on, as he understood it, to stop development of his land in or around the 1980s. And he requested from the council all information, including internal memos, borough solicitor notes, which had led up to the TPOs being made. Council provided information within the scope of the request, but with some information redacted under Regulation 13. as it comprised personal data related to third parties. And the tribunal, the ICO decided that the council had been entitled to redact the information, and to give the game away, the FTT agreed. Now, it's quite an interesting point just to pull out in the first instance about the personal data exemption, whether it was engaged. One thing that was argued by Mr. Miller before the first tier tribunal was, well, actually, what the council should have actually done is look at whether any of the data subjects were still living, because the information dated back to 2006, and if that person wasn't still living, then there isn't a concern there. And what the tribunal said was no, no, we're not going there, and raised the concern, obviously raised the more general point that if it was incumbent on any public authority on receiving such a request to take steps to identify whether or not any individuals who might be identifiable were living or dead, then that was itself likely to create a disproportionate burden on the public authority in dealing with the request. And also, I think it's important to bear in mind the facts of that case, as the tribunal highlighted, there was no suggestion or evidence that actually any of these people definitely weren't around anymore. And in fact, the information didn't relate to whether they were around or not anymore. So it wasn't so closely connected to the request that you might even arguably have gotten to should the council have looked at this. So that's a sort of a by the by. But the more interesting analysis is the staged approach that the tribunal went through in terms of carrying out the exercises required under Reg 13. So I mentioned on the first overview slide that the obligation to do the balance for the public interest test that you have in Regulation 12(1)(b) doesn't apply to the data protection exemption in Reg 12(3). But that assessment does come in. It doesn't disappear. It's not irrelevant. It's just dealt with a slightly different way under the specific approach that applies to the data protection exemption under Regulation 13. Now, under Regulation 13, a public authority is precluded from disclosing personal data if either one of two conditions in Regulation 13 are met. And the first one, which is the relevant one for the purposes of this case, is that in a case where it falls within any of the paragraphs A to D of data in Section 1(1) of the Data Protection Act, that disclosure of the information to a member of the public otherwise than under the regulations would contravene any of the data protection principles, or Section 10 of the Data Protection Act 1998. And that was the particular cause of concern in this case. The FTT agreed with the ICO that the first data principle, which you have under the DPA, or had under the DPA, it's now also in the UK GDPR, was the relevant principle, and that's about lawful processing. And it took the view there are only two relevant bases of processing on which the council could lawfully disclose the information in this case, either with the consent of the data subject, which wasn't applicable in this case, nobody suggested been sought or gained, or secondly, the legitimate interest basis. And that was the one that was particularly looked at by the tribunal in this case. Now, essentially, that involves consideration of whether or not the person who's requested or to whom the information will be provided has a legitimate interest in processing that data. And the first tier tribunal in Miller said, in terms of doing the analysis here, we're going to look at 7 propositions that were laid out in a case from the upper tribunal from 2014, Goldsmith International Business School and Information Commissioner. Now, that case was actually a FOIA case. It was a request from the business school for information related to 2 of its students from the Home Office. And this is the first case I'm aware of where it's been directly drawn across and applied in the context of the data protection exemption in the EIR context, as it were. So 7 propositions. The first one is the 3-stage test you've got to look at is broadly that was set out in South Lanarkshire Council and the Scottish Information Commissioner 2013 decision of the UK Supreme Court, updated to reflect the change in language that you have in the UK GDPR as opposed to the language that was used at the time of the decision. So 3 questions under that that would be applied. Is the data controller or third party or parties to whom the data are disclosed pursuant to legitimate interest or interests? Is the processing involved necessary for the purposes of those interests? And are those interests overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data? So that's the 3 headline questions that you've got to look at in deciding whether or not you can apply this exemption on the basis of lawful processing. You've got to look at necessity before you can get to the 3rd question. Necessity carries its ordinary English meaning, being more than desirable but less than indispensable or absolutely necessary. So the test is one of reasonable necessity, reflecting the European jurisprudence on proportionality, although, and this is not my language, this is the language of the tribunals, this may not add much to the ordinary English meaning. 5th proposition is that involves consideration of alternative measures. A measure won't be necessary if the legitimate aim could be achieved by something less. So the measure must be the least restrictive means of achieving the aim. Proposition 6, where there's no issues regarding the individual's privacy rights, you can stop at stage 2. Conversely, where there are issues, you've got to go all the way through the 3-stage test. So in that case, the FTT upheld the decision of the ICO and the council's refusal decision to redact certain information. But I said most useful in this case, I think, for a really quite nice way of setting out how you should go through this if that exemption is potentially engaged. Finally, and quickly, class-based exemptions. Materials in the course of completed internal communications, Thornton Information Commissioner, an HS2 case. There's quite a lot of HS2 cases, I think it's fair to say, in the EI regime. This was really about information that was sought as between the DFT and HS2. HS2 refused to disclose the information, relying on it being material in the course of completion, not the document itself, but the decision-making process fed into was the material in the course of completion, and also then relied on internal communications at risk of giving the game away. FTT was satisfied that both were engaged on the particular facts of that case. It's worth having a look at because there's a bit of a discussion around what the relationship was and how the process worked in practice between HS2 and the DFT. And then just to pick up on 2 cases in the context of Reg 12.5, adverse effect on matters specified in Reg 2.5, public safety, another HS2 case. This was about planting of saplings. To cut the matter short, by the time it got to the tribunal, the request had been narrowed, and the tribunal was pretty satisfied that there was already so much information out there in the public domain put there by HS2 that it couldn't see that the additional information really made a difference. So perhaps something to be aware of in terms of balancing how much information you're putting out and whether that might cause a problem if you're looking to rely on an exemption going forward. Interesting on its facts, just more one to be aware of. And then finally, and this is perhaps a more important case, at least from my perspective, request to National Highways Limited for advice received from a QC, which they referred to in a letter to the DFT saying, well, we've changed our mind from what was our preferred option pre-consultation. We now have a different preferred option for the route of a bypass. NHL refused to disclose it, relying on the exemption in 12.5b. There's no LPP specific exemption in EIR compare and contrast the FOIA. ICO agreed the exception was engaged, but held it public interest was in favour of disclosure. FTT overturned in very, very, very robust terms. The decision was surprising and clearly wrong for 9 reasons. What I've done on the slides, because I've got my time warning, I've set them out in summary on the slides. But key ones to pull out was it was a failure to attach sufficient weight to the critical role of LPP in the justice system. There were a number of factors that also played in aid there, including the proximity of the advice, the fact the matter was live, and also to point out at 9, which is quite interesting, that the ICO had put too much importance on the presumption in favour of disclosure. The fact there's a presumption in favour of disclosure isn't enough in of itself, they found in that case, certainly to overweigh the very, very strong interest in maintaining the LPP exemption, and if there was no other reason why the exemption should be overridden. With that, I hand on to James.
Hi, thank you. So what I'm covering is the role that the Aarhus Convention has played in our domestic EIR case law. And that's going to involve a few things. One is what the status of the convention is in our domestic law. Secondly, the role of the convention in our case law on the EIR to date. And then also to ask the question whether, given the likely diminishing future role for EU law in this context, could that make the Aarhus Convention increasingly important instead? And I'm going to start by looking at perhaps the leading case and certainly the most off-cited case on the Aarhus Convention and its role in interpreting the EIR, and that's the Henny case from 2017. And in that case, the Court of Appeal recognised that the EIR give effect in our law not just to the directive, but also, of course, to the convention on which the directive itself was based. And so the Court of Appeal said the starting point was that the EIR must be interpreted as far as possible in the light of the wording and purpose of the directive, which itself gives effect to international obligations arising under the Aarhus Convention. Now, that language must be interpreted as far as possible in light of the wording and the purpose of the directive is, of course, the Maurici indirect effect approach. And I ask you to note that because I'm going to come back to its significance in a moment. But the Court of Appeal then said that if you looked at the recitals to the Aarhus Convention, which obviously the directive itself was based on, they emphasize in a number of different ways the importance of environmental information to public participation in decision making, and also in terms of access to justice. So in terms of the three pillars of the Aarhus Convention, the first pillar on access to information is seen by the convention, not surprisingly, as fundamental and essential in order to facilitate the other two, which is public participation and access to justice. Without the information, going back really to the themes in Alex, is talk, without the information, how can you meaningfully participate and or bring legal challenges? Now, the Henny case was about whether information concerning a project assessment review of the communications and data component of the government's smart meter programme was environmental information under the EIR, which, as you know, is defined as any information on measures affecting or likely to affect the state of the elements of the environment or factors affecting those elements, so a pretty wide definition. And it was said that a tribunal should apply the definition in the EIR purposefully, bearing in mind the modern approach to the interpretation of legislation, and particularly to international and European measures, such as the Aarhus Convention and the directive. And again, the way the line will be drawn between what is and isn't environmental information should be done in accordance with and purposefully with the directive and the Aarhus Convention. And so it was then said by the court that the starting point for the analysis was the recitals to both the convention and the directive. And it says they refer to the requirement that citizens have access to information to enable them to participate in decision making more effectively, and the contribution of access to a greater awareness of environmental matters and eventually to a better environment. They give an indication of how the very broad language of the text of the provisions may have to be assessed and provide a framework for determining the questions of whether in a particular case information can be properly be described as on a given measure. And again, in reaching the views, both the directive and the Aarhus Convention were integral to the decision made. So what's clear from that leading case is the Aarhus Convention, along with the Environmental Information Directive, have played a really important role in interpreting the EIR in domestic law, and they have an important role to play potentially. But the role of the directive in this regard, while preserved by the Withdrawal Act, is likely to be reduced significantly now by the Rule Act. Now, while as a result of the EIR rule themselves remain and be now called assimilated law, government thought it useful that, having got used to one new phrase, retained EU law, we might as well move to another one, just to spice things up. There are some key features really of this legislation so far as we're concerned. EU supremacy, which was retained at least in part by the Withdrawal Act, is ended. The Mar leasing principle is also said to be ended, at least according to the explanatory notes. Very wide powers are given to restate, reproduce, revoke, or replace assimilated law. And of course, under the Withdrawal Act, the courts were not bound by post-Brexit CJU case law, and there was an ability for the higher courts, albeit on a quite limited basis, to depart from pre-Brexit case law. Now, under the Rule Act, it's going to be made easier to depart from both European and domestic retained case law. There's a new test for departing. Lower courts can, and this is a truly bizarre provision, make a reference to the higher courts on whether to depart. And indeed, there's also provision for government through Attorney General and law officers to intervene to invite the departure. Now, all of that Section 6 stuff, which is frankly, some of it's completely bonkers, but that is subject to commencement provisions, so it doesn't come in automatically like the rest of it. But the reality is that Mar leasing has played a really important role in this area in terms of the way in which the EIR have been interpreted, having regard to purposes of the directive. VESCO, which Jacqueline's already discussed, is just one example of how important Mar leasing's been in the EIR context. And of course, under rule, we have what you might call reverse Mar leasing, because there's a new priority rule, which is that you should you read and give effect to relevant legislation in a way which is compatible with domestic legislation. And where there's a conflict between that, then domestic legislation is to take priority over the assimilated law. So I don't know whether that's reverse Mar leasing. It may be. So that leads us then to the convention. And the convention, what is its status? Obviously, it's an international treaty. Traditionally, of course, they have a restricted use in our domestic law unless they're incorporated. That's because of our strictly dualist system, and of course the constitutional orthodoxy of that is the courts have no jurisdiction to construe or apply treaties that have not been incorporated. They're effectively non-justiciable, and unless they have been incorporated, again, they're not part of our law. They can't be directly effective or create rights or obligations under international under national law, where a court nonetheless has to take a view about what international conventions say. Where they're not incorporated, there's quite a standoffish approach that the courts take, not surprisingly, I suppose, given the orthodoxy. Now, back in 2009, in the Morgan and Hinton case, Lord Justice Carlmurth, as he then was, looked in detail at the status of the convention in our law and made a statement about its role. Now, that statement was obviously very much fixed into where we then were with both European law and the convention overlapping in terms of their influence. Now, that case was not about information; it was about costs under Aarhus. But some of the observations, at least, obviously some things have moved on because of Brexit, but some of the observations that were made by Lord Justice Carlmurth remain relevant if you're considering the status of the convention. And the reality is, even though we're talking about a convention, even if you're talking about an unincorporated convention, and clearly here there is an argument, of course, that what you're dealing with here is legislation that was made to implement the Aarhus Convention, at least indirectly. And the reality is that you've got a whole series of provisions that are certainly sourced from the Aarhus Convention, and therefore the Aarhus Convention remains a very relevant consideration in terms of how you would interpret the EIR, notwithstanding that as an international convention, it's not been directly incorporated. Nonetheless, it's an important consideration in terms of interpretation. Now, that deals with its status. A few things really. I just want to kind of run through the main ways in which so far the convention has played out in EIR case law. and I'm going to do that quite briefly before returning to some other issues to finish with. So there are different areas where Aarhus has had a particularly kind of important role, I think, in the case law so far. The first, as we've already seen from the Henny case, is in relation to the scope of environmental information. And clearly, Henny is one example of that, but there are others here. The East Sussex case was one of a series of cases concerned with whether property information for the purposes of property searches was environmental information. And in all of these cases, and in a number of others, reference back to the Aarhus Convention and related Aarhus materials, like, for example, the Aarhus Implementation Guide, which I'm coming to, are very common in this context in trying to understand the scope of environmental information. The next area where there has been a huge influence has been on establishing the scope of public authorities under the EIR. That position is far more complex, really, than under FOIA, because you haven't got a defined list, and so the concept of public authority is potentially wider under the EIR. The leading case is Fish Legal, which is a case in which I acted for the UK government in Luxembourg, and Jacqueline acted for the water companies in the domestic litigation when it returned to the UK. And that was, of course, the case that held that the privatised water companies were public authorities, overturning an earlier case called Smart Source. There was extensive reference in those cases, both in the domestic courts, in the CJEU, and in the Advocate General's opinion to Aarhus in relation to this. But similarly, there is extensive reference to the Convention and the Implementation Guide in other cases that have looked at the concept of public authority. So the Poplar and Cross cases, which were about housing associations, the Heathrow Airport case, which obviously was about whether Heathrow Airport itself limited was a public authority, which the ICO held it was, but the First Tier Tribunal overturned that, and sadly, for reasons related to economic consequences of COVID, it never went any further. And then Bruton, which is on the Duchy of Cornwall, and then Network Rail, which obviously concerns whether Network Rail is a public authority for the purposes of the EIR. And then the third source of case law that has pulled in a number of references to the Aarhus Convention is really on the exemptions, which Jacqueline's already talked about. I'm only going to mention these briefly, but the Gloucestershire case deals with unfinished and incomplete data, reference back to the Implementation Guide and understanding that. Pinkerton is another example in this context, and again, very much pulling in from Aarhus the importance of the public interest in disclosure. And you'll see in the last one, in Department of Transport Information Commissioner, well, of course, the judge also added as an additional reason, by reference to the recitals of the Aarhus Convention, that greater public access to environmental information is thus an end in itself. And with respect to the court said, I think Mr. Dunlop was correct in his submission before us that this last reason involves some circularity of reasoning. So court appeal weren't persuaded that that really took one very much further. And then the Dransfield case, which Jacqueline's already mentioned, which is perhaps the leading case that started looking at manifestly unreasonable. Again, there were multiple references to the Aarhus Convention to try and understand the scope of that concept, both under the EIR, but also relatedly under FOIA. In terms of exemptions, there's also a few other cases which I mentioned there. I think what's interesting here is that the DEFRA cases, and Burkitt is obviously a really important case about the fact that a public authority, if it says it's not going to disclose for exemption A, it's not bound by that. When the litigation goes on, it can switch and add new exemptions to rely on in the litigation. And there was some consideration about whether Aarhus prohibited that approach, and the court said no. But perhaps interestingly, what has also been held in the Office of Communications case is that it would not be acceptable under the directive, and so presumably also under our regulations, to add exemptions that are not already listed. So the list is closed, and that conclusion was very much one supported in the court's reasoning by the Aarhus Convention itself. Briefly, territorial scope. This was a case which was actually arguing about the scope of FOIA and whether it would apply to people who were based outside the UK and seeking information. Now, in considering that that issue, the court or the tribunal rather had regard to the fact that under the Aarhus Convention there is no territorial limitation on it, so you don't have to be within a convention state to request environmental information from a convention state, and the tribunal thought that was relevant in not causing a division between the two regimes that we have, FOIA and EIR. And then just briefly on the implementation guide, what is it? It's a document that's published as guidance to the convention itself. I mean, the convention is quite short. The implementation guide is very, very lengthy. It's an explanatory document. It's a relevant consideration if you're considering the scope of the convention. It has been referred to in numerous domestic and European cases as a source of guidance on what the Aarhus Convention means, but it is in no way binding. And in terms of the European Court's approach, I've set out a few things that have been said there about it being relevant material, but doesn't have any binding effect. And then I think perhaps my favourite AG comment ever in looking at the implementation guide was to say that it was not entirely valueless, which is probably one of the most cutting reviews I've ever seen of a document. There are numerous domestic cases where there have been reference and reliance on the implementation guide. So if you have an EIR issue that you're in litigation on, you do need to look at the guide. There is lots that is useful there and potentially relevant. And then I think the last thing I want to look at really in terms of the substance of this, in terms of case law anyway, is just how decisions of the Aarhus Compliance Committee in Geneva have been considered. And in relation to those, they are not binding. Lord Carnworth in Walton said the decisions of the committee deserve great respect. That was in the context of public participation, not information. This is one of the topics we've covered in the blog, which I've given you the reference for. There are not many committee decisions about the UK on information. Most of them, of course, are about costs or other matters. And so actually there isn't much in our domestic cases on information rights that have looked at the content of committee decisions. And I could only find Evans in the divisional court and the RSPB case in Scotland. And then I think two more things really. One is just to mention that there is a linked access to justice right in the information field. So Article 9.1 and Article 9.3 apply when you're seeking to challenge through the court's decisions about access to information and give you various rights in terms of access to justice. Not much considered by our courts, but except in the Evans case, which is obviously about the Prince Charles letters, there is extensive consideration there of Aarhus in the litigation in the context of understanding the issues that were raised there about being able to override the decision of a tribunal through a ministerial certificate. And then the last thing is EIA case law. So the convention has been relied on to interpret the meaning of other information in the EIA regulation. So not the EIR, but the EIA regulations. So it's another area where potentially the Aarhus Convention can play a role in interpreting the scope of our domestic legislation that was, of course, based on EU law. So with that, I think we come to questions, and I'll ask all of our panel to put on their cameras and their microphones. And we've had a few questions in. I think the first one is a question that probably could be answered by some or all, but perhaps all of us really, which is why might someone send a request for information under the EIR rather than FOIA, and would it actually matter which one you request it under? And I mean, I think, the two observations I would make about that are that, first of all, there clearly are differences between the scope of FOIA and the EIR. So, for example, EIR covers more public authorities potentially than FOIA, and the exemptions are not precisely the same, although, as we've seen, the courts and tribunals tend to try and achieve some kind of consistency between them. But I think more importantly, the case law is absolutely clear that if your request relates to environmental information, whether you cite it as an EIR request or a FOIA request, a public authority is required to treat it as an EIR request. The case law has been very clear on that for a very long time. So in a way, it doesn't really matter which one you ask for it under, although you may actually help your own cause if you think it's environmental information to refer to the EIR. I don't know if anyone's got anything to add on that one. No. Okay.
Well, I just tend to do it under both, to be honest,
Yeah.
and that'll go with the one that's more beneficial to whoever's asking for it.
Yeah. Yeah. I think that is perfectly acceptable, and in the end, the obligation to get the right one is actually on the public authority, not the requester. So that's probably where we go. So Nick, question for you: if you were seeking to get your hands on a viability assessment, what do you think the better route would be, EIR or Section 100D?
I think if you're in a post-2019 decision, Section 100D should be pretty good, and that's probably the route I'd go down with, particularly given duty of candor issues, as Alex has raised and talked about. I mean, there's no harm. Well, there's normally no harm in doing both, subject to the fact that if you're going to be running a Section 100D JR under the EIRs, they might say it's ongoing litigation, as Alex has outlined. So I'd normally start with the litigation and trying to get my hands on it using the litigation route, and then if that doesn't work, have an EIR as backup. But depending on the precise scope of your challenge, you can make clear that this information has been sought pursuant to the litigation and the EIRs, and the EIRs have said no. And so that at least makes it very clear for the court that if it is relevant, it should be disclosed, and there is no other route.
Thank you. And Jacqueline, just on yours, the Miller case that you discussed, question: whose data was at issue in that case, and do the recent pronouncements from the admin court on redacting, or I suppose we should say not redacting, officials' names, might that have any bearing on the Miller?
I think in the Miller case, we don't get the exact details for understandable reasons as to what information was redacted, but it seems that it was individuals linked to a particular residential address, and the tribunal says evidently council employees. So I think in terms of one of those categories, we are arguably getting into the, if I put it, the swift redaction territory. Now, obviously, we're looking at two different things there, because I think a thrust of the judgments that we get from Swift back in, I think, July last year and in November last year, was that they've been redacted on, names have been redacted on grounds of relevance, but actually it could be unhelpful in terms of, given the duty of disclosure was, sorry, the duty of candor, sorry, important distinction, was there about understanding the decision making, to assist the court in understanding the decision making, that redacting names routinely and email addresses could actually confuse rather than assist. So I think there's not a direct read across necessarily, but I would be very, very, very surprised if when looking at these DPA exemptions on third-party data, somebody doesn't pray those cases in aid as going to that balancing of fundamental rights and freedoms test that I mentioned. So I think it's not a direct read across, but I think it's probably something that's going to end up being put into the mill. Great,
thank you. Now, Alex, you mentioned the Police Superintendent Association case in the context of talking about your request for disclosure in the Whitehaven litigation, which I'm sure in a minute Nick and I can remind you of the outcome of. But rather than that, I think one of the things you said was that as part of the case that there was a suggestion that both Mr. Justice Fordham and Mr. Justice Ousley as was can't be right on this. Now, I mean, I think it's fair to say that Fordham J's listing of 10 principles of candour has been quite controversial. I mean, I have heard some judges speak about it, and they're not best pleased with it. I mean, my concerns with it are that the Lord Chief Justice published a paper on duty of candour principles and a suggestion about how we might amend the rules back in 2016, and it was written by 2 senior admin court judges. The principles in that are very different to Miss Justice Fordham's, and the reason that project wasn't taken forward was because I think it was decided it was just too complex to start over providing for what candour did and didn't require. I'm also not sure that, in fairness to Miss Justice Fordham, that all the relevant cases were before him, and there are certainly cases out there that are not consistent with his principles. I mean, in any event, I've suggested at least 9 of those 10 principles are obiter, because they weren't actually an issue in the case. When I suggested that to a judge, not in court but outside of court, the judge said he fundamentally disagreed with me because all 10 were obiter. So I don't know whether actually you've got any view on that. I mean, I think we're going to see.
Sounds to me like it's ripe for the Court of Appeal to consider this. If we've got such a confusion between what applies and what doesn't, I think it's about time someone had a good hard look at it.
Yeah,
hopefully not too soon. Maybe the end of this year.
Yeah, or maybe we could just forget about the obiter and get on with the principles when they've actually been applied to decide the case. Okay, now I think there's one more question that came in. I'm not really sure who wants to take this one in, but the question is, for the public interest test, how important are the private interests of members of the public, e.g. in obtaining information that may be useful to them in private litigation? Now, I'll open that up in a minute. My thought is, first of all, it depends on what you are describing as private litigation, because we are concerned here with the environment, and under the Aarhus Convention, for example, some private litigation like nuisance is environmental litigation that's caught by the scope of the convention. So, I mean, if you're trying to obtain information from public authority to pursue a private nuisance claim, I think that is fully and absolutely within the Aarhus Convention, and therefore there is a public interest, and quite a strong one, not obviously overriding, but quite a strong one for disclosure. If you're after environmental information for something that is much more private litigation outside of that, then it might be more difficult. But I don't know if there's any thoughts on that one.
For my part, James, I agree with you. I think it kind of depends on, certainly under the EIRs, you need to identify the relevant interests, basically. And it seems to be a sort of public interest type focused approach that the tribunal's taking. So it's why do you need it? And as you say, if it's for nuisance or something like that, then there's arguably a strong interest in disclosure, particularly if you can't get it from other way. But if it's a landlord and tenant issue, for example, or a pure contract dispute, it's going to be harder to identify the sort of the public interest element in that. Bearing in mind, of course, as a background, if you've got this ongoing litigation there and a document is relevant, then there are mechanisms under the CPR for you also to get hold of relevant documents.
Yeah. So, I mean, if it's private nuisance, I think that's quite clearly environmental litigation. I think all of the Aarhus Convention factors would be supportive of provision and disclosure. Right. Well, I think that's probably time for us to wrap this up. Thank you for joining us. Thank you for your questions, and obviously thank you to our speakers. And I hope everybody found it useful, or at least I hope that everybody didn't come to the same conclusion as the European Court did about the implementation guide, that it was not entirely valueless. Hopefully there was some value in some of the things we said. Thank you very much.